Hello, Assalamu alaikum. How are you all? So, you know that every time I have a discussion on the legal matters or the non legal matters, but in today's discussion, I'd like to talk about the legal matters of mm, legal arbitration, mediation. More specifically, I'll discuss about the ADR procedure in Bangladesh. So first of all, I have to mention what you mean by the ADR. ADR is a in true sense, it's called as the alternative dispute resolution. That means whenever the formal adjudication system, that means our court system or court procedure, is only the adjudication system of the formal court procedure, whether the people can get justice, whether people can establish the rule of law, reinforcing the rule of man, rule of just and rule of equity. So, but I think that in the recent time, our court has lots of duties as they could not achieve the success in providing the access to justice, providing the just to the common people. So, whether the common people will not get the justice, will not get the proper remedy from the court, this is one kind of big dilemma for our court procedure and the court structure. So, from this perspective, I can think that alternative dispute resolution or ADR can be a very good choice in reshaping and in reiterating the rule of law, rule of equity, and access to justice that is very much important, rational, and proactive for the common people's getting remedy. But in recent times in Bangladeshi government they has made a law. The law's name is Bangladesh Legal Aid 2008. But I think that 90% of the common people they have no idea about the legal aid, who will get the legal aid, how the government will provide the legal aid, and what do you mean by the legal aid. So this is the common concern of the common people, but I think the government is providing these types of proactive rules and legal definition for the common people, but the common people they are not getting any kind of success from the rule of law and the legal aid act 2008. Even you know that in Bangladesh there is a very big institutions, that means blast Bangladesh Legal Aid and Services Trust, Ain o Shalish Kendro, or BNWLA, Bangladesh National Women Lawyers Association. So these are the proactive measurement in providing the mediation, arbitration, conciliation, or what should I say, and bargaining procedure. But I think that ADR is more better than any other informal platform or the informal procedure. Some people would like to say that ADR is a formal adjudication system. Yes, I'm admitted ADR is a informal adjudication system. It is not the formal adjudication system. But my query is that through the ADR procedure, people can easily get the justice with a very short time. That is actually not possible from the regular process of our court procedure or the court proceedings. So why it is not possible from the court procedure in establishing the just equity and proper justice throughout the court? The first reason is that court takes too much time. So whether it will take too much time in a specific portion, in a specific region, in a specific matter, how you will provide the justice despite there are lots of elements of injustice existing in our common field, common society, and common criteria. So this is the big problem. It takes too much time. For example, if you would like to get a justice in a specific civil matters from a district judge court in Bangladesh, then it takes more than 20 years to get a single verdict in a matter of the civil suit in Bangladesh. So this is one kind of big problem related to the ADR, more specific in the mediation arbitration. But I think that if the people is going to the ADR mechanism, if they take the advantage of ADR in their common development, in their common phenomenon, then it is very easy to establish the rule of law, rule of just, and rule of equity. So why ADR is important in our common lifestyle, in our common dimension? The first of all, it will reduce the time that I have already mentioned. The general and common lifestyle of the court procedure, it takes too much time in providing the justice in a single civil or the criminal matters. But if you see the legal matters, if you see the ADR system, it will provide you the justice with a very short time. with a very short time doesn't mean it will provide you justice randomly or promotely. That means if I make a basic comparative discussion with the time consumed by the court system or time consumed by the ADR mechanism will get the preference in providing the justice to the common people with a very short time. The second reason is that ADR is very allurable. For example, if you'd like to get a justice in the ADR mechanism, you can take the help of the third party. You can take help of the individual people, and these types of individual people will reshape the stakeholders as a third party, as an individual party. But before that, he have to neutral. He have to individually honest in his personal life and in his collective life. The third reason why ADR is important in Bangladesh, the recent statistics said that more than 45 lakhs suite is literally pending. So if you make another suite right now in the Bangladeshi court system, it will make another dilemma for providing the just and equity for the common people in Bangladesh. So having lots of controversies in the equity measurement and in the ADR measurement, I think that ADR is the first best and first personalized way than the other mechanism, than the other stakeholders and the other elements who are gradually working for providing justice to the common people. So this is one kind of big fact. The fourth reason is that why ADR is important and rational. I would like to say that ADR is convenient in the time of 21st century because court procedure definitely takes too much money. For example, if a common people or ordinary people whose national income or gross national income is less than $2,000, it's too much impossible for those person to get the remedy for the court procedure because our stakeholders are taking huge amount of money from the common people as they could not afford the money in their common lifestyle and in the present lifestyle. So in that mechanism, in that sequence, ADR can be a very good procedure whether the common people, the ordinary people, the people who has no money, the people who has already been declared proper person from the formal court procedure. This types of person can go to the court of ADR, can take the advantage of Bangladesh Legal Aid and Services Trust. This will be so much convenient and impactful for its life. So the question may arise when the common people will go to the ADR court or when the common people will go to the court system for getting the remedy with ADR. So in that mechanism, in that perspective, I believe that the common people will go to the ADR mechanism in the petty offences. And you know that ADR will not be applied in the mechanism of the hard rules, in the mechanism of the criminal matters. In criminal matters, ADR has no possibility, no implacability, and ADR has no impact in reshaping and removing the dilemma from the informal legal procedure. And according to Section 345 of the Code of Criminal Procedure, it is said that some types of compoundable offense. So, if people would like to make a very good realization and clarification, he can take the help of Section 345 or the new doctrine plea bargain concept in the present mechanism and in the present satisfaction. So I have already missed to say one of the basic advantage of ADR. So the basic advantage of ADR is that this is actually an easy procedure. You will not face the hard procedure as like the formal adjudication system or the court system in Bangladesh. While I'm talking about the informal mechanism and the informal system, wherein the common people, wherein the national people, or wherein the poor people can get the justice with a very short time, with a very short money, and this will provide them 100% pure remedy from the legal matters and the legal terminology. So these are the advantage and the concerns of ADR, but there are some of the disadvantages also. Sometimes the people who is actually the ADR, who is actually stakeholders of the ADR mechanism, they could not follow the principles of natural justice and the natural satisfaction. Whenever you will not follow the natural justice in providing the just and equity, it is technically illegal and inconvenient according to Article 35 of Bangladesh Constitution because it is mentioned that during the time of trial every person should be heard. no person will not be condemned unheard. This is also mentioned in a principle. That principle name is ori altram partem. So in our legal procedure, outside and inside legal terminology, it has a great impact, reinforcing the natural justice and the natural principle for providing the just equity and proper justice to the common people. I think that Bangladesh government, they will follow this types of strategy and strategical principle in following the international level, in following the natural justice principle for the ends of justice in the future time also. Assalamu alaikum.